Hello everyone, thank you for joining us at today's Ius Laboris client webinar on Coronavirus and Privacy, Clash of Fundamental Rights. My name is Annie and I'm the Business Development Coordinator at Ius Laboris, and I will be facilitating this session for you. Our presenters today are all lawyers from the Ius Laboris firms in the Netherlands, Spain, Luxembourg and the UK. I will now hand over to our first speaker, Philip Nabben from the Netherlands. Go ahead, Philip, you are welcome to start.
Thanks, Annie, for the introduction. Dear listeners, the coronavirus is throwing many new challenges at employers, and we're all facing the far-stretching consequences of the national lockdowns in different shapes and forms. The key challenge of employers during these strange times is to deal with these national lockdowns and make use of the various national government funds to keep the business going. And in the meantime, employers will no doubt also want to contain the spread of the virus in their company. But they are also faced with restrictions relating to the privacy rights of their employees following the GDPR. And this webinar is aimed to navigate you through the European and various national rules and hopefully give a helping hand in performing this balancing act. José Miguel from Spain will in a minute talk us through the international context, and we will then talk about the privacy aspects of working from home. Marie from Luxembourg will take care of this. And last but not least, some governments are actively exploring the use of COVID tracking apps. And Alexander from the UK will comment on this, both from a general perspective and from an employment perspective. And each of the subjects will then be followed by a quick country-by-country, country-specific comment by the four of us. And by the way, please do feel free to type questions if you have them. We will make sure to leave some time at the end of the webinar to discuss at least a selection of these. The legal dilemmas. Even before the coronavirus hit, it was already difficult for employers to navigate between their obligation to ensure a safe workplace and, on the other hand, the obligation to protect the privacy of employees. And the most important reason is the GDPR is rather strict when it comes to processing employee health information. And with the advent of the coronavirus, employers are facing new dilemmas. We hear questions from our clients, like, for example, can we take people's temperatures on entry? And I'm not talking only about employees, but also, for example, a maintenance worker who has to access the building because he has to repair your company's printer or something. Or can we, or do we perhaps have to, pass on the name of an employee who is infected with the coronavirus to their colleagues? Or in case we ask the employee to stay home until they get their testing results, do we have to pay their salary? Another question, may we send an employee home if they show signs of sickness, like coughing, sickness, fatigue, shortness of breath? And what available remedies does the employer have if that person refuses? Or questions like, what data do we register when an employee reports ill? Furthermore, an enormous number of people are now working from home since the lockdown in many countries. And some, or maybe many of them, may barely or even never have worked from home before. This, of course, triggers privacy risks, like home internet not being protected, the use and also the potential loss of USB sticks, people leaving their laptop open in front of a street view window while going away from their desk, the use of unprotected video chat services. It could be anything. We receive questions like, how can we assure that working from home happens GDPR proof? But we also get questions like, can we monitor our employees' productivity when they are working from home? And if yes, how could we do that? The GDPR gives exceptions to the general processing limitations, such as when consent has been given by the data subject, or when there is a legal obligation. But normally this does not help an employer because the employer normally does not have a legal reason to process medical data. And because consent, as you may know, in an employment relationship is no valid ground for processing, because consent by an employee is generally deemed to not have been given freely. The current question among many employers is whether preventing the further spread of this pandemic, or in other words, the protecting of your employees, can be regarded as an exceptional situation that overrides certain privacy obligations. And some governments are actively exploring the use of tracking apps. The possible use of such a government-issued app gives, of course, rise to various new types of questions. For example, as an employer, could you compel your staff to install it? And what if you do, and what if the employee refuses to make use of it? Can you deny access to the building to such an employee? Or if the app alerts you that an employee must stay in quarantine for 2 weeks because the app says so, is that person still entitled to salary? Or more broadly, there are also many ethical questions about a government-issued app that potentially processes sensitive personal data of millions of people. Questions like, are we absolutely sure that they have been sufficiently tested on a short notice? Are they absolutely necessary? Or in other words, is there no other way of getting the results you're aiming at, in view of the GDPR's principles, data minimization, lawfulness, and what have you? And how do we know for sure that all data collected by the apps is deleted afterwards? And last but not least, have we thought enough about the risk of a data breach involving health data of millions and millions of people? We will go over all of these questions in this webinar. And take the next slide. Oh, I'm sorry, I'm a little bit too fast here. We have set up this webinar. We chose to use a scenario of us four advising a company, XYZ Limited, a large multinational company with businesses in, say, 10 or 15 countries in Europe. And the company wants to understand the do's and don'ts related to the processing of personal data in the attempt to control the risks of coronavirus and protect their business. So, José Miguel, before we can show the differences between the countries, we need to start off by giving an international context first. Could you take over from here and give a European context?
Yes, of course. Hello, everyone. This is just a second. Of course, as a way of introduction, let me tell you that whether we like it or not, due to COVID-19, we have jumped definitively into the data protection era, and employers must really be very well aware of that. Okay, and European employees fear that their personal data may be processed inappropriately by government or any private company, and even more if we talk about health information. As you said, indicate, Philip, the concern is what if the data remains at the disposal of the employer after we overcome the COVID-19 and makes a different use of what's thought initially. To this regard, please bear in mind that Recital 46 of GDPR fixes the legal base when processing personal data. The essence of it lies in two elements. First, vital interest of the employee or another employee, and second, public interest. And such legal base in that recital is thought to control epidemics and avoid its spread. That is the spirit as well of the Article 6 that highlights that legal base for processing will be lawful if serves to legitimate purposes and clearly justifies monitoring epidemics and their spread in humanitarian emergencies. However, there is a general provision contained in Article 9.1, since employee health information qualifies a special category of data to be processed. There are exceptions to this general provision, and they are found in the second point of Article 9, which indicates in letter B, says, such processing will be lawful to carry out obligation and exercising rights of the control of the data subject. Here, obviously, the data subject, the control of the data subject is employer. An example, for instance, could be the limited questionnaire raising questions to the employee connected with their health and their relatives, or, for example, with whom they have been in contact in the last days. And then second, the letter H, it says, indicates such processing may be necessary for preventive or occupational medicine medicine diagnosis, etc. An example of that could be taking body temperature or conducting tests to the employees at the entry, as you already indicate. But that said, although the General Data Protection Regulation of 2016 contains the necessary safeguards and rules to legitimately allow the processing of personal data in situations such as the present one, when there is a health emergency of general scope called pandemic, each member state has considered at its sole discretion how to tackle the coronavirus and what measures to implement. That is foreseen in Article 15 of the e-Privacy Directive of 2002. Such measures, at any cost and any scenario, will be scrutinized by the ECJ, European Court of Justice, and also by the European Court of Human Rights, considering three elements: necessary, appropriateness, and proportionality. Then we must jump to what the European Data Protection Board says. In this regard, we are pleased that this board launched a statement last March 19, emphasizing that data protection rules and GDPR should not refrain the national regulators to adopt measures in order to tackle and fight against COVID-19 and its spread. But even in these special circumstances we have to live, data control must always ensure its protection. We may affirm that public health authorities and employers may process such personal data, but believe me, they are closely watched not to exceed themselves and commit any infringements. To this purpose, it is of the essence that the individuals are duly informed about, first, processing, second, for how long their data will be kept, and third, for what purposes. Last, a final word on mobile location data was given, indicating to the rule of thumb is to preserve the anonymity of the individuals. Well, we see that there is a shortage of reliable tests at this moment. The European Commission now seems to embrace the adoption of coronavirus trackers as a new data source. We assume that during the next weeks, we will get more information about it. Meanwhile, through all this chaos and uncertainty we are all navigating, one thing that stands adamant clear above the rest: the different data protection agencies, DPAs, of each member state have not really worked close to each other and unfortunately have failed to comply with Article 60 of the GDPR. When it comes, it says, to cooperate and act in a coordinated manner with each other. Thus, in response to massive questions by employers, here you have a flavor of different approaches of different countries that gave a preliminary stage. For instance, in Italy, a press statement indicated employers should refrain from collecting systematically and widely information on the presence of any systems, but were permitted to check employees' body temperature and stop them from entering the premises if they have a temperature at least of 37.5 Celsius degrees. When it comes to France, measures that may breach privacy of people are banned, since such data is subject to a very special protection according to the GDPR and Code de Santé Publique, and systems to read the body temperature were not allowed. Finally, in Germany, gathering employee health information about COVID was admitted, but did not concrete whether taking body temperature to employees and visitors was lawful or not. To this regard, and taking a look at every country here to complete the puzzle, I am curious, Marie, what are, for instance, the guidelines to be followed by employers in Luxembourg?
Well, thank you, José Miguel. In Luxembourg, the Data Protection Authority has confirmed that the protection of employees' health and safety is a valid ground for processing their data, including health-related data, to prevent spread of COVID-19 into the workplace. However, Luxembourg authorities have reminded that those processing of data shall remain proportionate and compliant with GDPR requirements. In that sense, some practices are strictly prohibited. For instance, the systematic and large-scale collection of personal data, like taking people's temperatures at the office entry, is strictly forbidden. Similarly, the use of medical questionnaires or asking people to sign statements of absence of coronavirus symptoms is clearly also forbidden. And finally, employers shall refrain from disclosing names of employees who have been infected by the virus. Instead of that, the DPA recommends employers to focus on raising awareness among their employees, training them, and empowering them with the responsibility of reporting any suspicion case of infection. They also advise to provide dedicated channels to enable employees and people to report coronavirus infection or suspicion case in a privacy-compliant way. And finally, employers are not doctors, so they are advised to direct people to competent public health authorities and occupational health services in case they might suspect infection with the virus. Basically, the GPA provides for recommendations, but made it clear that in case the sanitary situation will command the government to take more restrictive measures, of course, those measures will prevail. That's for Luxembourg.
Yeah, and I think it's me. Is it me from the United Kingdom next? I think so. Forgive me. Sorry, Philip, it's you.
Yeah, it's me. Thanks. Sorry, I also clicked. Yeah, from a Dutch perspective, as explained by José Miguel, certain exceptions are mentioned in the GDPR regarding the prohibition to process health data, but unfortunately, these exceptions have not been included in the Dutch GDPR Implementation Act. And next to this, as you can see on this slide, the Dutch DPA, despite Corona, is still super strict. What you see here are some quotes from their website. Let me name a few. For example, as an employer, you may not check your staff for Corona yourself. Only a company doctor may do that, and the company doctor then only shares the result with the employee. Another quote, you cannot ask your employees about their health or take a test for a check. Another, it is not allowed to keep track of the reason for reporting sick. And finally, your employee does not have to tell you that he or she has Corona. In other words, we here see a totally different approach than, for example, Italy, where there are much more possibilities on the side of employers. That might, of course, have to do with the fact that with the extreme scale of the outbreak in northern Italy. But the Dutch are still super strict. And I note that there was already a lot of criticism against the strict approach of the Dutch DPA before Corona kicked in. And we even see published case law where courts often take a more practical and a more pragmatic approach if privacy is raised as an issue. Anyway, an employer will be forced to make a choice between protecting the health of its employees, which is, by the way, also a legal obligation, and on the other hand, the protecting of the privacy of employees. The Dutch DPA on the website seems to offer some leeway for a relaxation of the rules, although all very generally worded and not at all specific to the employment environment. So in short, it will not be possible for employers to be completely GDPR compliant when they want to abide by the legal obligation to protect the health of its employees. So our advice to our clients is always, if you do process personal data in view of that particular legal obligation, at least observe all the GDPR principles: data minimization, proportionality, swift deletion of the data, security measures, informing employees, etc. Alexander, what do you think? How does the approach from the Dutch watchdog compare to the guidelines in the UK?
Thanks, Philip, and hello, everyone. Yes, indeed, it's very, very different. The base position in the UK is that there is far more processing, coronavirus or not, of health data in relation to employees. This comes from two main areas. One, the common law duty of care that employers owe to their employees, and from statute, the Health and Safety at Work Act 1974. So, corona or not, before the processing of health data is very common. We regularly receive reports from doctors, we regularly receive reports from occupational health practitioners, and we regularly receive reports from employers themselves. If they're off sick for a short period, they have to file a return to work interview and discuss their symptoms. Not in any great detail, in a proportionate and necessary fashion. But as you can imagine, as we've come into the coronavirus crisis, nothing has really changed. And you can see here I've listed some of the ICO's guidance, but asking individuals about their health, the ICO has confirmed it's reasonable for companies to ask people whether they have coronavirus symptoms, and indeed in the past visiting a country. Of course, it's subject to standard GDPR principles such as proportionality and necessity and transparency and enhanced security. But overall, it is much more relaxed in the UK. And this does apply as well to things like temperature checking. It is perfectly possible to check the temperature of employees. You just should do it in a proportionate and necessary manner. So don't check it and keep a list of it for 100 years. Check it and keep the details for as long as you need them. It may only be that you need the details for 1 minute, and then you send the person home or you don't. So it's all about proportionality, necessity, and transparency. The ICO has also made given some guidance in relation to the way employees interact with each other. Can you disclose names of affected individuals to others? Because obviously one employee might want to know if they've been sitting next to potentially someone who has been diagnosed with coronavirus. The ICO's view is that an employer may do this, but only in very specific circumstances, only when it's proportionate and necessary. If possible, it's better to avoid the sharing of the name of an employee. There's just one more point that I want to make about the ICO's position generally. They've also released guidance suggesting that over the coronavirus period, that while it's not a carte blanche for employers and other data controllers to ignore data protection law, they will be realistic and reasonable in relation to enforcement action. So I've given one example on the slide here, which is very relevant to employers in the UK and indeed in Ireland, although not so much across continental Europe. The ICO said that whilst it can't amend statutory deadlines in relation to subject access requests, for instance, it does recognise that organisations might be taking more time to process requests. And so as long as you are communicating with the employee and the data subject reasonably, if you miss a deadline, unlike normal times, it is unlikely you will be heavily criticised for that. And Jose Miguel, what's the position in Spain?
Yeah, in Spain, Alex, we do have, I would say, a position closer to the British than to the Dutch. Here, the specifics are quite clear. Employers may apply measures to get health information, find out if employees are infected, and apply a contingency plan from health and safety angle. Then, regarding inquiries, obviously, they may conduct it, but on a limited purpose about symptoms, diagnosis, or quarantine, and avoiding, obviously, any other information not related to the coronavirus. Such info must be conveyed to the workforce, but without identifying the infected employee, except, there is an exception, authorities indicate otherwise. At the other end, employers must be really cautious, keeping the workplace safe and out of risk, and process data gathered for a limited purpose and kept for the necessary period. As you say, we cannot keep that information for hundreds of years, obviously. But last but not least, employees cannot keep information to themselves if they become ill. That is contrary to the Dutch standard position. They must disclose if they are infected by the coronavirus. Well, all in all, colleagues, here, to my mind, the conclusion here is the principles of proportionality and necessity must guide any decision when collecting employee health information and obviously align with our local regulations. That said, Marie, turning subject, what are the privacy concerns of teleworking?
Thank you, Jose Miguel. Now, we can see that employers are facing very challenging and difficult times as they have to keep on fulfilling their legal and business requirements while most of their employees are now working from home, where their private and professional lives are more than ever intermingled. So how does COVID-19 affected employers' duties in terms of protection of privacy and personal data. First, it is necessary to remind that according to the GDPR, employers as controllers are and remain accountable for the security of personal data. And this is regardless whether employees are working from home, whether they are working with their professional or own personal device, and employers remain liable even if the data breach is committed by a third party. So we can see that this is extremely important for them to keep control on data security during the specific context of COVID-19. They are accountable for implementing appropriate security measures. And most important is to note that, still according to the GDPR, employers have to ensure that the level of security is appropriate to the risk. And we can see that the current situation has definitely increased employers' exposure to risk in terms of security of personal data. First, people are working from home and they are sharing their space with spouse, kids, and potentially other relatives. So this definitely increases the risk of unauthorized access to personal data or accidental destruction. They are working with potentially with a home computer from their personal Wi-Fi connection, and employers, like we say, are still responsible for any potential breach that will be committed in that context. So it is necessary to take and potentially to upgrade or enhance your IT security measures. Make sure that you are using VPN, you are using updated firewalls or antivirus softwares. It is also essential to remind employees of their obligation in terms of data security. Of course, if you have existing IT policies like clean desk policies or data protection policies, you should ensure that the contents are duly reminded to employees, and why not updating your contractual arrangements with them, making sure that they are aware of their own responsibility in ensuring protection of data. Last but not least, we've seen an increase in the use of remote working solutions like video conferencing tools like Zoom, and you may all have heard about the scandal that affected the Zoom company last week, where we observed that thousands of personal accounts, email address, passwords have been sold on the dark web, potentially exposing employers' corporate information to hackers. We also know that Zoom faced what we call Zoom bombing, namely people entering virtual meeting rooms while employees were having virtual conferences. So here, employers need to make sure that every remote working tools used by employees while they're working from home are secure enough to ensure a sustainable security requirements. Failing to do that will definitely expose employers to huge consequences, notably in terms of reputation, but also financial sanctions can be imposed on them. You should also make sure that if you, for instance, are a banking company or a financial company, that your industry security standards are complied with. And as employees are working in exceptional working conditions from home, employers may be tempted to monitor employee productivity and to use remote monitoring systems. Of course, if you are having existing monitoring system in place, you still have the right to use them. But it is clear that this current situation, COVID-19, doesn't exempt employers from respecting GDPR principles and data protection rules. So first of all, right to respect for private life and correspondence is still valid during that specific times. So permanent or undercover surveillance of employees is still forbidden. Principle of loyalty and transparency impose employers to inform employees when you are intending to use monitoring systems and to make sure that they respect the proportionality principles and data minimization. You should also assess the need to carry out data protection impact assessments, as this is an obligation set by the GDPR. Additional requirements from member states may also apply. And of course, you should make sure that you are complying with them. Basically, complying with surveillance principles is key, as we can see from country-specific that they may entail additional responsibilities on employers. José Miguel, can you please explain what could be potentially applicable in Spain in this regard?
Yeah. Thank you, Marie. Well, aligned with what you had just explained, Marie, Spain is really concerned about the exponential increase of phishing, ransomware, and other cyber attacks. Protection of data and security of information comes first, absolutely, in this scenario. Well, let me tell you something. Let me tell you that teleworking is currently implemented in Spain so far, but believe me, after this long lockdown and confinement, many companies will assume it culturally and adapt their activity. I'm just thinking that maybe traveling to Madrid to have a meeting with the Works Council for 2 hours maybe could be just replaced with a connection by a platform like a Zoom or Skype, as you mentioned. Anyway, regarding employees, this change considers two scenarios. One is teleworking with company sources. That mandatorily requires a policy with clear technical instructions and security. So all employees must strictly comply with its use and connection, etc. The responsible of information security must take care really of confidentiality and integrity of the personal data. The other scenario is instead of company sources, we have the scenario of employees using personal devices to telework. Then, in that scenario, company must facilitate clear and precise instructions about the protection of the device, which must count with antivirus, firewall, operating system, and software duly updated. Information, as you already indicated, Marie, must be protected with a VPN. Obviously, we have to avoid any open Wi-Fi and use only company's email and programs provided by the company, and even apply encryption to storage devices. Well, it goes without saying that to reach these goals, we need to train and to give guidelines, sufficient guidelines to our employees so they apply in accordance and in an adequate manner. Philip, what about in the Netherlands? What is your opinion about this?
Yeah, for the Netherlands, I can more or less echo both your recommendations, the recommendations that Marie gave generally, and also specific for Spain. They are more or less are the same for the Netherlands. I especially echo the recommendations of Marie about taking appropriate IT security measures, reminding employees of existing IT and privacy policies, etc. In short, COVID-19 simply does not exempt employers from their data security legal duties. Unfortunately, there isn't much guidance you can find on the information website from the Dutch DPA, other than a few tips in case of working at home, which have more or less been dealt with already by you, José Miguel. So they are more or less the same. And when it comes to employee monitoring, COVID-19 is the same more or less. COVID-19 does not change the restrictions on employee monitoring. Alex, could you tell us about the UK's specific views, if any, on the privacy experts of working from home?
Yeah, for sure, Philip. I obviously echo all the same views that have been expressed so far. Again, there are two aspects that are clearly demarcated, and the ICO has commented on them. One is the controller duties to protect data. And broadly, they've said the same kind of security measures need to be taken into account. frankly, if your security positioning was poor before COVID-19 appeared and it's poor now, you're going to be in trouble. The strange thing in the UK is that home working has been very common for a long time, and obviously even more common in the last 3 or 4 weeks. But many organisations had already thought about their security positioning. They had already thought about the training that they should give to employees. So for many of the clients that we're advising, it is just a sort of touch up on that training. And I must say, for anyone in Europe, it is well worth looking at the UK's National Cyber Security Centre guidance. They have some wonderful short infographics that are quite easy to build into, 10 or 12 do's and don'ts to circulate around employees so they can understand very clearly what their obligations are and what the risks are in relation to some of the things that Jose Miguel spoke about, ransomware, phishing and malware attacks and so on. The corollary, of course, is the controller duties to protect data subjects in terms of their privacy rights. And again, the UK, much like health and safety and health data, has been more relaxed perhaps than continental Europe on monitoring, in that monitoring in the UK is a little bit more common. You still have to comply with the principles of transparency, proportionality and necessity, and we always recommend doing a PIA, if not a formal DPIA, when you're doing ad hoc monitoring, and certainly any form of covert monitoring is very restricted. But the ICO has been very, very clear that they don't want to see what they term compliance creep with monitoring. They want to see employers trust their workers, and they don't want to see new technology being used to overly monitor productivity and so on. That is a very great worry for the ICO. And if you do start doing that in the UK, when the dust settles, there will be complaints and there probably will be trouble. And I think, Marie, you're going to summarise what the Luxembourg position is as well.
Yes, indeed. The pandemic does not exempt employers from their legal duties in relation to data security and does not neither eliminate the restrictions on employee monitoring. So what has to be bear in mind that is in Luxembourg we have additional data protection requirements when it comes to employee monitoring. Well, we have a specific procedure which requires employers that before implementing any monitoring systems, they make sure to inform employees and staff delegation, provide them with very detailed information on how the monitoring system works. But last but not least, employees and their staff representatives are allowed to file a specific request before the Data Protection Authority to ask it to assess compliance of the monitoring system before it is implemented by the employer. And employers are not entitled to start monitoring before the expiry of this 1 month delay within which the DPA is expected to issue its opinion. It is also important to remind that offending employers that will not comply with this procedure may face criminal prosecution. So this is not something which is ordinary and not directly related to privacy issues, but it's also important to understand that monitoring employee productivity in companies with 150 employees or more cannot be implemented by the employer. There must be a common agreement with the staff delegation. Otherwise, monitoring of employee productivity won't be allowed. So, still speaking about monitoring, let's now discuss with Alex how EU member states are now planning to implement tracing app as a way to fight a spread of coronavirus.
Thanks very much, Marie, and I will be quite short. I'm very conscious of time. Someone has just asked me just to repeat the website in the UK. It's the National Cyber Security Centre, and if you type that into Google, they have lots and lots of very useful resources. Just in relation to the COVID-19 app, I'll just do a very brief summary of what we're looking at here and then move on to the employment issues. Apps seem to be the number one goal now for people to exit the very strict lockdowns. And the view is that an app will be able to tell someone when they've been in contact with someone who potentially has been ill, and that then should lead to an interruption on infection chains and reduce the risk of further transmission. forgive me for sounding like an expert, a medical practitioner. I'm not. I'm very interested in both compliance creep, but also medical competency creep, which seems to happen. Everyone seems to know everything about everything, so forgive me if I'm sounding like I know more than I do. However, in any app, there are going to be enormously important data protection considerations, because the app will depend on collection, use, and potential disclosure of a significant amount of personal information. The World Health Organization describes contact tracing as the process of identifying, assessing, and managing people who've been exposed to disease to prevent onward transmission. It has mainly been done through manual intervention at very early stages. South Korea and Singapore held up as the prime examples of what we should all apparently do. But this is extremely difficult with millions of people, so we're looking currently at different tech solutions. GPS is not accurate enough. It can only be accurate to something like 4.9 or 5.5 meters, which is well outside potential zone of infection and so on. So what companies are looking at is the use of low energy Bluetooth, sometimes known as Bluetooth relative signal strength indicators, to track interactions between phones without tracking location in any way. So in some ways, privacy by design is already being built in because the companies are not necessarily looking at location tracking. What happens is that when users of phones come into contact with each other, the Bluetooth-based contact tracing will work out how close they were, and when people report that their symptoms or their diagnoses, there will be a ping out to those that were in connection with them, and they will be given advice on whether to self-isolate or so on. No, this is in no way going to be perfect. It's not going to differentiate between people who are living together, no idea if they're in a hospital setting. So there will be over-reporting. Also, there are problems in that it needs to be on a phone, and not everyone in the world has a phone. And of course, it also needs to be universal. It needs to work across Android, it needs to work across Apple Store, and ideally, it probably also needs to work across borders. In the UK, the NHS and the NHSX, which is the tech arm of the NHS, are going to be releasing an app in weeks, and I understand it will be happening across Europe as well. I think most parties are going to rely on the Google and Apple the contact tracing framework, which is going to use Bluetooth low energy, as I understand. And various governments have made comment on this. The EDPB has made comment. I mean, I put the ICO comment on the slide there, and that they believe the contact tracing framework is broadly compliant with GDPR. But of course, it depends on how the apps are used. The main point, and this is summarised by the EDPB, does the GDPR apply? Of course. The EDPB summarises it very nicely. The development of the app should be made in an accountable way, documenting with a data protection impact assessment all the implemented privacy by design and privacy by default mechanisms. So we need to think about access to data and purpose, the categories of data collected, data retention, data storage, legal basis, security, and so on. And all these, of course, then frame the employment considerations. Can an employer force its personnel to install the app? I think across Europe there will be a big difference on choose your own device arenas versus bring your own device arenas. A choose your own device, I've chosen an Apple iPhone of some kind, but Lewis Silkin owns it. It is very likely under our choose your own device policies that I am going to be told by my employer to, certainly in the UK, to install the app. And very likely under our health and safety obligations and our duty of care to other workers, it probably will be a mandate from, well, I'm actually a partner, but my employer, that I should use the app. But it's probably very different for a bring your own device setting where people are using their personal devices. And of course, what about a retail environment? You know, you might have 500,000 employees, but none of them have a personal phone, and phone use is just not important within the employment context. So there will be difficult issues to work through there. Secondly, is an employer entitled to know if and when an employee receives a notification? Again, I suspect it goes back to the very first issue that we discussed with Jose Miguel in relation to what is a country's view of health and safety data. It sounds like in the Netherlands, possibly it will be harder to force an employee to tell you this kind of information or anything related to potential health issues related to the employee. Whereas in the UK, it probably will be easier to do this as long as there's a transparent notice and everything is proportionate and necessary. The last three questions are all broadly similar in that can an employer deny access to the workplace? Do they have to pay them if they deny access? Broadly in the UK, the position is if someone has a genuine illness, you are probably going to pay them. But of course, we need to look at the quality of the apps. We need to look at how the apps work, and each employer will have its own policies, and each country, of course, will have its own nuances in relation to sick pay, contractual sick pay, and what needs to happen. I think, just bearing in mind time, I'm going to move on to Jose Miguel, just to give a few Spanish country specifics.
Yeah, thank you, Alex. Well, when it comes to Spain, so far 6 regions in Spain have approved an official act just with the purpose of decongest and deviate official health assistance phone numbers, as well as to offer official information to be trusted by the citizens. Well, this app serves to run the auto-diagnosis. I don't know the reliability of such auto-diagnosis, access to guidelines on how to act and get updated information, official information, and then reminders to keep track of the health condition of such citizen or employee. And then finally, only healthcare professionals and competent authorities may have access to this app. This is just what I have to say from Spanish perspective.
For Luxembourg, the head of government has expressed reluctance to support the development of the COVID-19 tracing app at national level. Probably the size of the country may be a reason why he tends to be reluctant to such an option. Prime Minister has repeated that Luxembourg's commitment to protect citizens' privacy and personal data. Anyway, he also mentioned that in his eye, a European application would be a better, more consistent and more efficient option, as we have so many cross-border workers who comes from France, Germany, and having different apps would, of course, not be efficient enough to fight coronavirus spread.
Yeah, regarding the Dutch government, they are still selecting a partner to develop the app, and up until now, not yet with much success. The Dutch government yesterday made it clear that they are determined to continue trying to develop the app, and this is followed with concern by experts and by the Dutch Parliament. That's all I can say for now. Alex?
Yeah, and just to summarise the UK position, as I say, the ICO has given a green light to the contact tracing framework, and it is, as I understand it, likely that the NHS app is going to be released in the next 2 weeks. It's already in beta testing with 3,000 or 4,000 people, I understand, and I think they're testing it on a military base in terms of the levels of how close people are and so on. However, she is concerned about compliance creep. There are some reports that the NHS might be able to de-anonymise location data, although I think that may be wildly off the mark, bearing in mind that the Bluetooth Low Energy, use of Bluetooth Low Energy to actually understand people's locations and so on. But really, it's to watch this space and then apply it to the employment context with all the things that we've talked about already: proportionality, necessity, transparency, wearing that hat, and you should be able to get to the answer that you wish. I think I will move on to Philip, who's going to wrap up.
Yeah, thanks, Alex. I think 4 conclusions can be drawn here. Our client, XYZ Limited, the multinational company, he seems to be confronted with the fact that despite EU's attempts to standardize privacy rules, these privacy rules in the various EU countries are still fragmented, especially when it comes to dealing with corona. So that means that all questions like, may I take an employee's temperature, etc., must be answered country by country. On the other hand, questions related to working from home can be answered more uniformly. Employer must consider the same kinds of security measures. And last but not least, the introduction of the app, still uncertain, and it gives rise to various new questions, and we are going to monitor that closely and keep you all informed, for example, through the Ius Laboris website. Switching to the questions, through the central team, I received an interesting question. What if an employer, this is about the monitoring of an employee's temperature. What if an employer checks the temperature on entry before entering the premises of the employer, reads the display of the thermometer, and decides based on that if that person can enter or not? And then the thermometer is simply reset. Are we then even processing personal data? Or in other words, is the GDPR applicable or not? my answer would be that one could argue that GDPR would then not apply, but on the other hand, the privacy rights of employees go, of course, further than just the processing of their personal data. As we know, the right of privacy as described in the European Convention of Human Rights, that right of privacy extends to the workplace. Alex, what do you think?
Yeah, I agree with you. I think there is a possibility that would remove the processing from the GDPR. Although I would, I think, recommend there that clients still proceed cautiously and probably still treat the data, however limited it is, as if it is personal data under the GDPR. Provide very clear transparency about what you're doing. And if that transparency simply says the data is deleted after a nanosecond, well then so be it. It just, I think, would avoid complaints later. And of course, transparency helps with engagement, and you want employees buy-in with this. And I also suspect although this is not my area, and it's much more the area of people on the call, but I suspect for those of you who have unionized workplaces, there will be significant discussion with unions about these kind of ideas like temperature testing and so on, and possibly even, Philip, the way that use of a tracking app will engage with the workforce. So if you can be transparent, that will presumably help you with your union negotiations as well. So I think I agree with you, but I still think I might, just for belt and braces, treat it as if it were GDPR standard data.
Annie, do we have time for one quick final question, perhaps?
Yes, sure. Take 3 minutes.
Okay. Question. Another interesting question, perhaps for you, Marie. Can an employer monitor if the working place is in line with national occupational health and safety rules by, for example, asking them to take a picture of their home working location? Would you comment on that?
Well, of course, this is employers' duty to make sure that teleworkers are complying with health and safety instructions, even when working from home. In the meantime, we have, as we discussed, a privacy restriction that prohibit any intrusive processing of personal data. So I think, yes, such an option will be possible, but of course, making sure that the pictures only show the space which is reserved for telework, not the whole apartment or the whole room, but only the space which is dedicated to home working. So once again, proportionality, and data minimization.
Exactly. Yeah. Okay, thanks for that. I think that in view of the time, Annie, I'm handing over to you.
Thank you, Philip. So we have now reached the end of today's session. As previously mentioned, if you have any queries for the presenters, you can also contact them directly by email. If your query is related to a different jurisdiction, you can contact me at annie.laxo@iuslaboris.com or go to the people pages of our website to find the right contact. For some insightful information and further updates on the coronavirus, I recommend you visit the Ius Laboris Corona page, which is regularly updated as the situation evolves. From there, you can upload our coronavirus guide for international employers with information from 57 countries. Finally, I would like to thank everyone for attending today, and thanks also to our presenters for their insights. So with that, this webinar will now be ending. Thank you.